The president of the National Right to Work Legal Defense Foundation says the Biden administration's proposal may revive a union-backed legal theory that would take away individual rights and freedoms from workers. One America's John Hines has more.
In a Wall Street Journal op-ed, National Right to Work Foundation Legal Defense President Mark Mix exposes how, quote, one of President Biden's top labor appointees wants to protect the integrity, in quotes there, of union elections by stopping workers from ever voting in one. And that would be in reference to National Labor Relations Board, NLRB General Counsel Jennifer Abruzzo's plan or proposal. And Mark Mix, you are the author of this op-ed in the Journal. How would this plan or this proposal on the NLRB work?
Well, Jonathan, these are interesting times when it comes to labor unions and how the Biden administration and the bureaucrats inside the Biden administration are dramatically trying to increase unionization by bureaucratic fiat. What's happening is the organized labor has been unsuccessful in organizing workers over the last several decades, to the point where 6.1% of private sector workforce, only 6.1% of private sector workers are in unions. Now, union officials talk about the popularity of unions and the growing interest in unions, but the bottom line is this. Workers are rejecting union representation because employers are taking care of employees. And while that is something that labor unions across the country can't stomach, what they've done is they've come back to Washington and they said, we need increased power. And Jennifer Abruzzo, the general counsel of the National Labor Relations Board, the highest ranking legal official at the board, who has really unreviewable discretion about things that she does, has decided she's going to make it her mission over the next several years to increase unionization, not by allowing workers to choose whether or not they want to join a union, but punishing employers to recognize unions on behalf of employees by making it really difficult for employers and employees to talk about the idea of unionization.
Is this a radical change? Is that what is going on here? I think somewhere in your press release or your op-ed, you call it a radical agenda, a radical change. Why is this so radical, do you suppose?
Well, it's radical because it's taking away individual rights and individual freedom. If you can't vote whether or not someone's going to be your, quote, representative in the workplace, I mean, that's a radical proposal. And stopping employers from talking to employees about situations that involve their workplace and involve the continuity or the success of a company is something that's pretty radical.
But doesn't it center on this issue about the card? Of using the card to vote rather than a secret ballot? I mean, isn't that what you're saying? So are they actually preventing a vote, or is it just you have to use this card to vote?
Yeah, what Abruzzo is intending to do is going back to a standard that applied in the workplace prior to 1949, when if unions could demonstrate that they had a majority by any means, by, I guess what the word in the actual statute was, substantive means, then the employer would be forced to recognize all those workers.
And this would revive this so-called 1949 Joy Silk ruling. And why is that material here, the Joy Silk ruling? What does that have to do with Ms. Abruzzo and her proposal?
The Joy Silk Mills precedent that was established was allowed basically the unions to come forward and say, we've got a majority, there shouldn't be an election, and therefore the union or the employer must recognize the union as the bargaining agent for all employees, even those that may not have signed a card. So just a hypothetical example would be, all of a sudden one day you have 10 employees at your workplace and 6 employees walk out and hold a sign saying, we want a union. Under the Joy Silk Mills standard, that would be evidence of a majority, no matter how those people got out there and who gave them the signs and whether they're being paid to be out there. If you could see a majority by any means of workers that wanted a union, then you would immediately recognize the union. In 1969, a Supreme Court case called Gitzel Bargaining overturned that and said that the employer, if they had a belief or if they just said that we would like the workers to vote, it allowed the employer to request a secret ballot election despite the presentation of these cards or other means that would indicate that the union perhaps has a majority of the workforce on their side.
Mark Mix, thank you for talking to us on One America News, sir.
Thank you, Jonathan. Appreciate the opportunity.
For all our viewers asking where One America News is heading in the future, we would like to introduce you to OAN Live. OAN Live is the best way to stay up to date on all of the hard-hitting, straight-shooting, national and international headlines. And the best part is, OAN Live is only $4.99 per month. All the credible, honest, unbiased reporting One America News offers at a fraction of the cost of cable. Just go to OANN.com to easily sign up for OAN Live and stay informed.